In April of 2019, a lawyer in Indianapolis named Wes Miller was doing something that, on paper, looked routine. He was filing class action lawsuits against car dealerships, 7 of them, eventually more. The allegation was narrow and unglamorous, not fraud in the cinematic sense, not odometer rollbacks or title washing or any of the things people picture when they imagine a crooked car lot. The allegation was about a line item, a charge that appeared on nearly every contract these dealerships had written, usually somewhere south of $200, $169 at one store, $199 at another, $149.95 at a third, small enough that most buyers never questioned it. Small enough that most buyers, if they noticed it at all, assumed it was a government charge, something the state required, like the title fee or the registration. It was not a government charge. It never had been. And under Indiana law, as it existed at that moment, charging it in that amount was arguably illegal. The statute was unusually clear. Document preparation fees had to reflect expenses actually incurred, not expenses estimated, not expenses averaged across the fleet. Actually incurred. If a dealership spent $4 preparing your paperwork, it could charge you $4. Charging $199 was, in the language of the Indiana Deceptive Consumer Sales Act, an unfair sales practice. Miller's math was not complicated. He said as much to reporters at the time. Dealers, he pointed out, were charging $175, $199, all somewhere just under $200. Unless they were buying a new printer for every set of documents, the number didn't make sense. The cases looked strong. The statute was on his side. The transaction records existed in every dealership's own filing system. Thousands of class members. A 6-year statute of limitations on unjust enrichment claims, meaning the exposure stretched back to 2013. 19 days after those lawsuits began landing, the Indiana legislature passed a bill. 21 days after that, the governor signed it. The bill rewrote the dock fee statute. It removed the requirement that fees reflect real dealership expenses so long as they stayed under $200. And then it did something else. Something that is the entire reason this story is worth 40 minutes of your attention. It made the change retroactive to 2013, not retroactive to the signing date, not retroactive to the start of the legislative session. Retroactive to 2013, which happened to be exactly as far back as those lawsuits could reach. The conduct that had been unlawful on Monday was lawful on Tuesday, and it had, according to the new text, been lawful the entire time. This is a story about a fee, but it is more accurately a story about what happens when an industry loses in court and wins in the legislature instead, and about the strange, quiet machinery by which something can stop having been a crime. Before the legal argument, the arithmetic. Because the arithmetic is what makes the legal argument matter. A documentation fee, doc prep fee, processing fee, conveyance fee, depending on which state you're standing in and which dealership group owns the building, is a charge added to the price of a vehicle to cover the administrative work of the sale, preparing the purchase contract, filing the title transfer, processing the registration, handling the loan documents if you're financing. That work is real. Nobody in this story disputes that the work exists. A title clerk sits at a desk, assembles a file, submits forms to the state. The file has to be accurate. Errors create liability. It is a genuine job performed by a genuine employee. The question has never been whether the work exists. The question is what it costs. Industry estimates put the labor at roughly 30 to 60 minutes per transaction. Call it 45 minutes for a typical deal. A title clerk's loaded labor cost, wages plus payroll taxes plus benefits, runs somewhere in the neighborhood of $25 to $35 an hour in most markets. Materials, filing supplies, the actual forms, call it another $10 or $20. Run that out and you land somewhere between $30 and $50 per car. Generous assumptions, slow clerk, high wage market, maybe $60. Now hold that number against what gets charged. In California, The dock fee is capped by statute at $85 for dealerships that are DMV private industry partners, $70 for those that aren't. That is close to cost. Slightly above it, but recognizably in the same universe. In Florida, there is no cap at all. Dock fees there routinely run $700 and up, and at high volume stores, they have been reported well past $1,000. Same paperwork, same 45 minutes, same forms. Functionally, the state-specific details differ, but nobody has ever claimed Florida's title transfer requires 14 times the labor of California's. The national average sits somewhere around $350 to $500. Virginia dealers commonly charge in the $700 to $900 range. New York caps at $175 and enforces it. Texas has no hard statutory ceiling, but the Office of Consumer Credit Commissioner established a $225 safe harbor, above which a dealer is expected to justify the number. Roughly 22 states cap the fee by statute, the rest do not. And in the states that do not, the fee floats to whatever the market and the customer's attention span will tolerate. Here is what that spread tells you, and it is the single most important observation in this entire story. If the dock fee were a cost recovery charge, it would be roughly the same everywhere. Costs don't vary by a factor of 14 across state lines for identical clerical work. The fee doesn't track cost, it tracks regulation. It is high exactly where the law permits it to be high, and low exactly where the law forbids it. That is not the signature of an expense. That is the signature of a profit center, one whose ceiling is set not by what the work requires, but by what the statute allows. Which is precisely why the wording of the statute is worth going to war over. To understand what happened in Indiana in 2019, you need to understand what had been happening in Indiana for the 6 years before it. Indiana's law said dock fees must reflect expenses actually incurred. Indiana dealers were charging $150, $175, $199. Those two facts sat next to each other for years without producing enforcement. Because of an arrangement that the dealers themselves would later describe, more or less openly, as the reason they believed they were in the clear, the Indiana Attorney General's office had agreed to a safe harbor. Fees under $200 would not typically be investigated. The office's own explanation given to the Indianapolis Business Journal was that this position came after receiving information and input from auto dealers. Read that sentence slowly, because it is doing a lot of work. The regulator responsible for enforcing a consumer protection statute adopted a policy of not enforcing it below a certain threshold, a threshold arrived at after consultation with the regulated industry. One state senator described it as a gentleman's agreement. That phrase circulated in the coverage at the time, and it is worth pausing on because it captures something precise, not a rule, not a regulation subject to notice and comment, not a statutory amendment passed by the legislature and signed by the governor. An understanding, a convention, a shared assumption between an enforcement office and the businesses it was supposed to be watching. Gentlemen's agreements have a specific structural weakness. They bind the parties who made them. They do not bind anyone else. The Attorney General's office could decline to investigate. What it could not do was extinguish a private citizen's right to sue under the statute. The Deceptive Consumer Sales Act gave consumers their own cause of action. It did not condition that right on the Attorney General's enthusiasm for pursuing the matter. So for 6 years, Indiana had two coexisting realities. The official one, in which fees under $200 were fine because the AG had said so, and the actual one, written in the statute books, in which those fees were unlawful and every transaction was accruing exposure. Nobody had tested it until somebody did. And when the Court of Appeals eventually examined this history, it dealt with the gentleman's agreement in a footnote that should be read aloud in every state capital. The existence of any sort of gentleman's agreement, the court noted, may be factually interesting, but it is irrelevant. It does not alter statutory interpretation. The motive of an individual legislator cannot be imputed to the entire legislature. Where a statute is unambiguous, the court determines intent from its plain meaning and does not go looking for reasons to read it differently. The statute said actually incurred. The statute meant actually incurred. Whatever anyone had agreed to over the phone did not enter into it. The chronology is the case, so here it is, plainly. The lawsuits began arriving in early April 2019. Cohen and Malad filed on behalf of customers of Butler Toyota of Indianapolis and the 11 rooftop Andy Moore Automotive Group. More followed. A Johnson County resident named Paul Clodfelter sued Beck Automotive Group on April 15th over a document fee of $149.95 he had paid in 2013. At least 7 suits, all seeking class status, all citing the same statutory language. The complaints allege that dealerships used the fees to extract additional profits from consumers in an unfair and prohibited manner, when what they should have been charging was the few dollars the paperwork actually cost. One suit alleged the practice had generated hundreds of thousands of dollars at consumers' expense at a single dealer group. House Bill 1237 was already moving through the legislature that session. It was not originally about dock fees. It was a vehicle, a bill in motion, with a number and a committee assignment and a place on the calendar. An amendment was attached. State Senator Aaron Freeman, a Republican from Indianapolis, introduced it. Its stated purpose, per the reporting at the time, was to codify the gentleman's agreement to take the informal understanding between the Attorney General's office and the dealers and give it the force of statute. The amendment removed the actually incurred standard for any fee under $200, and it applied the change retroactively to 2013. The vote was not close. The Senate passed it 40-6. The House passed it 92-0. 92-0. Not a single representative voted against it. Governor Eric Holcomb signed it in early May. He declined through his spokesman to comment to the Indianapolis Business Journal on why. Now, the retroactivity date. 6 years is the statute of limitations for unjust enrichment claims in Indiana. The lawsuits were filed in April 2019. 6 years back from April 2019 lands in 2013. Miller made the connection publicly and without much hedging. The dealerships, he said, were hoping the legislature would hand them a get-out-of-jail-free card. He said his firm would fight it. He said he thought it was unconstitutional, that there is a whole body of case law holding that a legislature cannot pass retroactive laws stripping people of vested rights. The reach-back distance and the exposure window were the same distance. That is either a remarkable coincidence or it is not a coincidence. And the arithmetic does not require a narrator to editorialize. There is a reason retroactive legislation makes lawyers uneasy, and it is not squeamishness about business getting favorable treatment. Legislatures pass business-friendly laws constantly. That is ordinary politics. The unease is structural, and it goes to the separation of powers. A legislature writes rules going forward. A court applies those rules to disputes that have already happened. Those are different functions housed in different branches, and the boundary between them is one of the load-bearing walls of the system. When a legislature changes the rules retroactively, while cases applying the old rules are actively pending in court, it steps across that line. It is no longer setting policy for the future. It is reaching into a live proceeding and altering its outcome. Indiana courts had confronted this before in a completely unrelated context, and the language they used is striking. In 2017, the Indiana legislature inserted a retroactive secrecy provision into a budget bill, 2 pages, added at 2 a.m. on the final day of the session, that would have blocked a court ruling ordering the release of certain state records. In 2018, Judge Lynch struck it down. Her reasoning was that the law had been designed specifically to alter the outcome of court proceedings. The General Assembly, she wrote, does not have the authority to determine the outcome of pending litigation. Passing that statute overstepped its authority and violated the Indiana Constitution's separation of powers by disturbing a pending case. She singled out the retroactivity clause specifically. Same legislature, same constitutional constraint, a 1-year gap. So the dock fee amendment arrived carrying a serious constitutional problem, one that had recently been articulated by an Indiana court in unusually direct language, which raises the question the rest of this story turns on. Did it work? The answer is messier than either side would have wanted and considerably more interesting than a clean win or loss. The constitutional challenge never got squarely resolved, and Butler Motors versus Benoski, which reached the Indiana Court of Appeals in 2021, the retroactivity question was raised and then sidestepped. The dealers argued the 2019 amendment was retroactive and constitutional, but the trial court had already treated the amendment as retroactive when analyzing whether it permitted the fees, and the consumers in that particular case had not argued it was unconstitutional. So the appellate court declined to reach the issue. It didn't need to. But the court added a note. It observed that dealers and consumers in other dock fee cases pending in other Indiana trial courts might well take different positions on constitutionality. It pointed to Mike Razor Auto Group versus Schroeder, a memorandum decision from June 2021, where a dealer had argued that applying the 2019 amendment would be unconstitutional, and where the parties simply proceeded under the statute as it existed at the time of the transaction. Note the inversion in that last one. In Razor, it was the dealer raising the constitutional problem. The retroactive fix was uncertain enough that different parties in different courtrooms found it advantageous to argue opposite sides of the same question. This is what a legislative rescue looks like when it does not fully take. Not a dramatic reversal, not a headline striking the law down, just years of litigation in which the central question stays permanently unanswered, decided around rather than decided, because in each individual case there turns out to be some narrower ground available. And then the consolidated case is settled, $13,521,600. The settling dealers denied any wrongdoing, as settling defendants virtually always do, and said they were resolving the matter to avoid expensive and time-consuming litigation. Class members received payments proportional to what they had paid. Someone charged $200, received twice the share of someone charged $100, $13.5 million, paid out over a fee that a statute had retroactively declared lawful. You can read that outcome two ways, and honesty requires acknowledging both. The dealer's reading: they settled a nuisance, admitted nothing, and secured a permanent statutory ceiling that ended the underlying legal exposure going forward. $200 per car, forever, no cost justification required. Measured across every vehicle sold in Indiana in the years since, that is worth substantially more than $13 million. The consumer's reading: the retroactive rescue didn't hold. Money moved. Thousands of people who had been charged an unlawful fee got some of it back, despite a law passed specifically to prevent exactly that. Both readings are defensible. What is not seriously arguable is the shape of the thing. An industry faced legal exposure, went to the legislature, obtained a statutory change, reaching back precisely as far as the exposure did, and passed it unanimously in one chamber. Indiana is one state, and this particular sequence has not repeated itself identically elsewhere, but the underlying dynamic is national, and it explains the map. Dock fees are legal in all 50 states. Nobody is claiming otherwise. Roughly 22 states cap the amount by statute, the rest leave it to the dealer. Several of the capped states now index their caps to the Consumer Price Index, meaning the number rises automatically every year without any legislature having to vote on it again. California tried to raise its cap in 2025. Senate Bill 791 would have taken it from $85 up toward $260. Governor Newsom vetoed it that October. 85 stands. That veto is the counterexample worth holding on to. These numbers are not laws of nature. They are the residue of specific fights in specific state capitals, and the fights go both directions. At the federal level, the Federal Trade Commission's unfair or deceptive fees rule took effect in May 2025, and the requirement that matters most for a buyer is disclosure. Dealer-imposed fees have to be included in the most prominently advertised price. That does not cap anything. It just means the number has to be visible earlier, which is genuinely useful and considerably less than it sounds. So here is the practical residue, stated without inflation. Find out whether your state caps the fee and at what number. Attorney General offices, state DMV offices, and state dealer associations publish this. If your state caps it, that figure is the hard ceiling, and anything above it is not merely negotiable, but unlawful. If your state does not cap it, understand that the number in front of you was set by a manager, not a statute, and that it bears no fixed relationship to any work anyone performed. In either case, negotiate the out-the-door total rather than any individual line. Dealers in capped states frequently will not move the dock fee itself, sometimes because moving it creates its own compliance problems, since a fee charged inconsistently across customers is harder to defend as a cost. What they can move is everything else. A fee you cannot reduce and a price you can are the same dollars. And watch for what the industry compliance lawyers call exotic fees. When a cap constrains one line item, the pressure does not disappear, it migrates. Registration assistance, digital filing, electronic processing, vehicle prep charges on new cars, for which, worth knowing, the manufacturer has typically already reimbursed the dealer through the destination charge. Enforcement against creative bundling varies considerably by state. The thing that lingers about the Indiana story is not the money. $13.5 million is a rounding error against national auto retail. It is the 92-0, not a single vote against, on a bill that removed a consumer protection standard and reached backwards 6 years to do it in the middle of active litigation brought by people who had paid the fees. There is no villain in that number. That is what makes it worth sitting with. No conspiracy is required to produce a 92-0 vote. It requires only that a bill be technical enough to look like housekeeping, that an industry be organized enough to explain what it wants, and that nobody on the other side have a lobbyist in the building on the day of the vote. The buyers who paid those fees were not organized. They did not know each other. Most of them never knew they had a claim. They had each lost $150, which is exactly the amount of money that is too small to fight over individually and enormous in aggregate. That asymmetry is the whole mechanism. It is why the fee exists in the form it does, why it is $85 in one state and $900 in another, and why the correction, when it finally came, arrived years later as a settlement check for a fraction of what had been taken. The dock fee is not a scam in the sense of being hidden. It is printed on the contract. You sign it. It is disclosed again under the new federal rule, and legal in every state in the country. That is the more uncomfortable finding. Nothing here happened in the dark. It happened in committee rooms, in recorded votes, in published statutes, in full view, at a scale small enough per person that no one person had reason to look. Which is worth remembering the next time you're at the desk, near the end, when someone slides a page across and points to a line and says, "That one's not negotiable, that's just the fee." Somebody chose that number, and somewhere there is a record of exactly who.